All right, so we got another one, May 2024. Let's just jump right into it. Gun rights, convicted felons, it's been a movement, Second Amendment since Bruin. A lot of things have been pending. Cases have been coming out in the circuit saying that felon possession of a firearm is unconstitutional. See some of those others, look on my channel and see some of those other cases. But let's talk about the newest one. We're in May 2024 now, and this is a case out of California. Denton or Durant, something like that is the name of the plaintiff. This is brand new, so I had a chance to look at it, but I think it's Durant. But it's out of the Ninth Circuit Court of Appeals. But that's the important fact. So this was a convicted felon. It was non-violent. It was a non-violent convicted felon. But the Ninth Circuit just ruled, 3-judge panel, 2 judges ruled, 1 did dissent out of those 2 rulings, saying that it was unconstitutional under the Second Amendment now, hence the New York Bruin standard. And now they threw out this guy's charges, vacated it for possession of firearm by convicted felon, thrown out, found to be unconstitutional. This is from the Ninth Circuit. And I'm gonna tell you what's so shocking. We've already been seeing these cases. It's already been shocking to see look like where this is going. But if you know anything about politics in court, the Ninth Circuit traditionally leans way to the left, liberal. So I was shocked that this court came out. It's usually the conservatives are the one who passed Bruin for the most part. Bruin was passed by the conservative justices of the United States Supreme Court. I expected something like a conservative court to do this as far as the Court of Appeals. But this again, Ninth Circuit Court of Appeals, known for liberal decisions out of California, has just found convicted felon, at least in this case, that is unconstitutional under the Second Amendment. Hence the new Bruin standard that they are now applying, rightfully so, looking at it back in the day, in the cowboy days, looking at how guns were treated then, and rightfully so, these judges are saying that 922G, possession of a firearm by a convicted felon, is unconstitutional. Now they're going to appeal this probably to the United States Supreme Court. We've already got a couple of cases like me and Slick been talking about that are loaded in the United States Supreme Court, and we should be getting some decisions here within the next month or two. But this is big here. Ninth Circuit has said this to go on Supreme Court. Huge. Get in the comment section. If enough of you guys comment and push this out, we'll see about getting an attorney, and maybe some of you guys that have this convicted felon can actually file and actually maybe be in the hopper as far as not because you have the charge, but just saying, hey, the government won't let me buy a gun. I think this is unconstitutional. So we're looking for maybe a lawyer that can take a bunch of those cases, start filing them in the federal lawsuit space. Anyways, this is huge. Comment on it. Hit that like button for me. Tell me what you're thinking. If this pertains to you, if you know someone, also if if someone's in prison, again, with just that charge, either possession of a firearm or possession of a convicted weapon, and the Supreme Court decides that this is these cases are unconstitutional, you could be walking, vacated, sentences going home, vacated. Anyways, get in that comment section, thumbs up, like it, subscribe to the channel. We'll see you on the next one.